All rise. The Superior Court of the State of California, County of Riverside, Department 1 is now in session. The Honorable Judge Phillips presiding. Please be seated and come to order.
Good afternoon.
Good afternoon.
Let me begin by introducing some of the people who are here in the courtroom to whom we already owe a great deal in terms of all of the effort that goes into putting on this countywide mock trial program. We have a very distinguished panel of sworers today, and I want to introduce them and thank them. Paul Zellerbach from the District Attorney's Office. Ryan Bowles, our interim public defender. Christopher Harmon, who's president of the Riverside County Bar Association. Judge Mark Cope, who's the presiding judge of the Riverside County Superior Court. And Judge Gloria Trask from the Riverside County. Also in the jury box and a very key part of the mock trial program for our county is Kenneth Young from the Riverside County Superintendent of Schools. And I'd like to introduce the steering committee members for our mock trial program for our county. John Wallen, who's the chairperson. John Wallen's a partner at Best Krieger, and he's the chairperson of the steering committee. He's put in many years of service to the mock trial program. Lindsay Rivas from the Riverside County Office of Education. Melissa Moore from the District Attorney's Office. Guy Pittman from the District Attorney's Office. Robert Rancourt from the Public Defender's Office. And Howard Goltz, another partner with Best Krieger.
Ladies and gentlemen, it's my honor to introduce the presiding judge for today's round. He's the Honorable Virginia Phillips, United States District. Well, he's a sitting judge with the United States District Court for the Central District of California. Please give Judge Phillips a round.
All right, at this time, I would ask the counsel, I guess we'll start with counsel on the pretrial motion to make their appearances before the court.
Yes, Your Honor. From the defense. Good afternoon, Your Honor. My name is Michael Williams, and I'll be presenting the pretrial motion on behalf of Ms. Adrienne Vega. May my co-counsel state their appearances as well.
Yes, please.
Good afternoon, Your Honor. Nisha Petrova for Adrienne Vega.
Thank you.
Good afternoon, Your Honor. Emma Cunningham representing Adrienne Vega.
Thank you.
Good afternoon, Your Honor. Isaiah Murtaugh on behalf of Adrienne Vega. Mayor Bailiff, please introduce yourself.
Yes.
Good afternoon, Your Honor. My name is Aisuna Malzada, and I'm your bailiff. May I please go over the courtroom rules with the audience?
Yes, please.
Throughout the course of the trial, I ask that all cell phones be turned on or put on silent. If you have not done so already, please take a moment to do so now. Also, all food, gum, and drinks, with the exception of water, are prohibited in the courtroom at all times. If you feel that you must leave, please do so between witnesses. Thank you.
May our witnesses also introduce themselves.
Yes, please.
Good afternoon, Your Honor. My name is Jessica Montezuma, and I am Adrienne Vega.
Thank you.
Good afternoon, Your Honor. My name is Kendall Morris, and I am Taylor Berard.
Thank you.
Good afternoon, Your Honor. My name is Kendall Beret, and I am Aubrey Voss.
Thank you.
Good afternoon, Your Honor. My name is Terrace Henry, and I am Dallas DeCamp.
Thank you. All right. For the prosecution.
Yes, Your Honor. Good afternoon, Your Honor. My name is Matthew Tiernan, and I will be arguing the pretrial motion on behalf of the people of the state of California. If it so pleases the court, may my co-counsel please introduce themselves.
Yes, they may.
Good afternoon, Your Honor. My name is Jennifer Cole, and I represent the people of the state of California.
Thank you.
Good afternoon, Your Honor. My name is Aaron Koppel, and I represent the people of the state of California. If it so pleases the court, may our witnesses please stand and introduce themselves in the order in which they will appear.
Yes, please.
Good afternoon, Your Honor. My name is Thomas Lee, and I am Quinn Liu.
Good afternoon, Your Honor. My name is Bailey Brown, and I am Cameron Douglas.
Thank you.
Good afternoon, Your Honor. My name is Megan Owens, and I'm Tony DeLuca.
Good afternoon, Your Honor. My name is Haley Moser, and I am Officer Kelly Wright. If it so pleases the court, may your court clerk please introduce himself.
Yes, please.
Good afternoon, Your Honor. My name is Andy Gonzalez, and I am your court clerk. If it so pleases the court, may I demonstrate the timing signals now?
Yes, please.
2 minutes, 1 minute, 30 seconds, time.
All right, thank you. Are there any other preliminary matters before we proceed to the hearing of the motion?
None from the people, Your Honor. None from the defense, Your Honor.
All right, then, Mr. Williams, you may proceed.
Thank you. The defense moves that this court exclude from trial all statements made by Ms. Adrienne Vega during an interrogation conducted in the back of a caged police cruiser. Those statements were unlawfully obtained.
Caged? How do we know that it was caged?
Well, Your Honor, this was a standard police cruiser, and all standard police cruisers are indeed caged police cruisers.
Well, when you say caged, what do you mean by caged?
Well, Your Honor, the barrier between the back seat and the front seat is indeed caged, as well as the windows. Bars separating them.
In other words, there was some kind of a grid separating the front seat and the back seat?
Yes, Your Honor.
All right, go ahead.
Those statements were unlawfully obtained in violation of Ms. Vega's constitutional rights. And the Fifth Amendment guarantees that no individual shall be compelled in any criminal trial to be a witness against herself. In the seminal case of Miranda versus Arizona, the Supreme Court established that police must notify individuals of their right to remain silent prior to any custodial interrogation. In the case at bar, there is no question that Officer Wright interrogated Ms. Vega. He suspected her of a crime and repeatedly asked her questions directly related to that alleged offense.
So are you arguing that it's significant that he suspected her of a crime?
Well, Your Honor, this is a factor to consider if it is conveyed to the defendant. And the United States Supreme Court...
Well, isn't it an objective test?
Yes, Your Honor, and the United States Supreme Court, in its Stansbury versus California decision, held that subjective factors are to be considered if they are communicated to the defendant.
All right, and what was communicated to the defendant how was it communicated to the defendant in this case that she was a suspect?
Well, to understand this, we must look at the totality of the circumstances and begin from the beginning. Now, Ms. Vega returned from a late evening walk to see two armed officers standing in her front yard. It is important to note that Tony DeLuca confirms that they left the flashing red and blue lights of the police cruiser on after they parked in front of Ms. Vega's house. Now, the officer then approached Ms. Vega, and after confirming Ms. Vega's identity, began a series of accusatory and incriminating questions. Is this your car?
Well, at what point did they become accusatory?
Well, the moment the officer began to ask, is this your car? I'm investigating a traffic collision. Are you willing to talk about...
Would you call those accusatory questions, or would you call them small talk? Didn't he begin by asking her about the swim meet?
Well, no, Your Honor. The conversation between the officer and Ms. Vega that was on the issue of the swim meet was conducted after Ms. Vega had already answered the officer's initial line of questioning and was seated in the back of the police cruiser with the door open.
All right, so you're focusing on the questions after she got into that took place after she got into the car.
The questions of custody was triggered once the police car was closed, once the door was closed, and the officer repeated the same line of inquiry that Ms. Vega had already answered. Now, these were the questions that were conducted unlawfully, but the questions that took place before Ms. Vega was in custody are still to be considered. And this is because Ms. Vega was in a detention before custody. And this is important to note because we look at the spectrum.
Why do you think, or why are you arguing she was already detained?
Well, this is important to note because if we look at the spectrum of police-citizen encounters, consensual encounter would begin here, and detention would lie between consensual encounter and custody. Now, the events that took place on April 19th, 2012 begin here at detention. And frankly, this is important because it is a shorter distance to evolve, a smaller evolution to become custody. However, even if the court were to determine that this did begin as a consensual encounter, there is still no doubt that custody is attached from the moment Ms. Vega is interrogated once again in the back of the caged police cruiser.
All right, but why did they get into the police car? Because it was cold outside.
Well, that was why Ms. Vega was seated in the back of the police cruiser. However, Officer Wright never explained why he shut the door to the police cruiser and fully enclosed Ms. Vega. And no reasonable person would be able to determine why they did.
So it's a reasonable person test?
Yes, Your Honor.
All right. So the question then becomes, would a reasonable person have thought that she was in custody by reason of the fact that the door was closed?
Well, there are many more factors that go into determining whether or not Ms. Vega was in custody other than the fact that the door is closed.
All right, and what are those factors?
Now, to begin, the fact that Ms. Vega was already detained, and she informed the officer that she was cold, yet the officer made clear that he was not yet done with his investigative detention and gestured towards the back of the police cruiser. Now, it is there that they exchanged briefly about Ms. Vega's swimming career. The officer then, without explaining why he was doing so, closed the door to the police cruiser, fully enclosing Ms. Adrian.
And at the same time, he got into the police cruiser. Now, does that help your argument or hurt it? I mean, he's cold too. He gets into the police cruiser.
Yes, Your Honor, and Officer Wright then conducts the exact same interrogation through the bars of the caged police cruiser. Now, Officer Wright conducting the interrogation through the bars of the caged police cruiser is an intimidating atmosphere. It is a police-dominated atmosphere. Now, other factors that should be considered when we are determining custody are the fact that when Ms. Vega turns to her right, she would see a 6'4", 250-pound officer standing between her and the front door of her home. Now, there's no question that this is definitely a police-dominated atmosphere, and those are the factors that go to custody. All right, thank you. Now, the United States Supreme Court, in its Thompson versus Keohane decision, held that reviewing courts must conduct a two-pronged inquiry. First, what were the totality of the circumstances surrounding the interrogation? And second, given those circumstances, would a reasonable person have felt at liberty to terminate the officer's questioning and leave? Now, the California Court of Appeal, in two separate cases, People v. Sudan and People v. Aguilera, identified critical factors that should be considered when determining the second prong of this Thompson custody test. Those factors include, was the individual being interrogated as a suspect? Were the officers confrontational or accusatory? what was the site of the interrogation, and what was the length and the form of questioning. Now, these critical factors compelled the determination that Ms. Vega was in custody by the time she was closed in the back of the caged police cruiser.
2 minutes.
In regards to the first factor, again, the officers suspected Ms. Vega of a felony hit and run, and through words and actions, communicated this to her. Again, they had arrived at her house.
How did they communicate that to her? Didn't they begin by talking to her about the swim meet?
No, Your Honor. Officer Wright began the interaction with Ms. Vega by asking her questions about the crime that had happened earlier that evening. The conversation between Officer Wright and Ms. Vega in regards to her swim meet happened after that initial line of questioning and before this line of questioning was repeated. Ms. Vega was placed in the back of the caged police cruiser with the door open after already speaking with Officer Wright and answering all of the questions Officer Wright had that evening. Now, this is where the officer spoke briefly about Ms. Vega's swimming career. Before Ms. Vega approached, the officers had already determined that the car she'd taken home that night was involved in an alleged offense and were in the process of towing it as evidence. Now, again, Ms. Vega answered all of the officers' questions and informed Officer Wright that she was cold. Officer Wright offered the back of the police cruiser as a place for the conversation to continue. Again, this is where they spoke briefly about Ms. Vega's swimming career. Then, without any warning, Officer Wright shut the doors to the police cruiser, fully enclosing his suspect. It was here that Officer Wright began the exact same interrogation. Ms. Vega even informed the officer that she was tired. However, Officer Wright chose to turn up the pressure.
I didn't hear you.
Officer Wright chose to turn up the pressure. He directly accused Ms. Vega, stating, "We think it's possible that you were the driver of the car that struck the bicyclist on Skyline and Grand," making clear to Adrian Vega.
Well, is that a direct accusation to say we think it's possible? Wouldn't it be a direct accusation if he said we think you did it?
Well, we have to take into account the context, and when we do, we will see that this is a direct accusation. Now, Ms. Vega had already once stated that she was not the driver of the car and that Tony DeLuca was driving the Bueller as it crossed the intersection of Skyline and Grand. Now, Ms. Vega stated that she was cold. The officer offered the back of the police cruiser and asked her the same exact questions again, communicating to her that he did not yet believe her initial line of questioning. And after Ms. Vega had spent 30 minutes informing the officer that she was not the driver and twice stating that it was Tony DeLuca, Officer Wright then stated, "We think it's possible that you were the driver of the car that struck the bicyclist." Now, this would make any reasonable person feel as if they were being accused, because this is an accusation.
Well, when you say any reasonable person, are you taking into account... No, I'm sorry, go ahead. I understand your point.
Thank you, Your Honor. Now, Officer Wright chose to accuse Ms. Vega. This was an accusation of guilt that was therefore structured to elicit an incriminating response from Ms. Vega. Now, because this was an accusation of guilt, and because Miranda warnings were required, any statements made by Ms. Vega must be suppressed.
30 seconds.
Thank you, Your Honor.
Thank you. All right, Mr. Chairman.
Yes, Your Honor. May I proceed?
You may.
The defendant was not in custody, and the defense's motion should be denied for 4 reasons. The defendant voluntarily approached officers and voluntarily sat in the officer's car. There were no objective indicia of arrest. The defendant did not know the police car doors were locked, and the defendant was...
No, but, pardon me for interrupting you, but didn't Ms. Vega actually say that she didn't know whether or not they were locked, but she felt that she couldn't leave once the door was closed?
Yes, Your Honor, Ms. Vega did state this. However, the defendant's subjective view of how she was feeling, if she could feel as if she were free to leave, is irrelevant in analysis of custody.
Why is that?
This is articulated in the Supreme Court case of Yarbrough versus Alvarado, where subjective factors and beliefs are found to be irrelevant.
All right, thank you.
Fourth, the defendant was not exposed to a police-dominated atmosphere like the one articulated in the case of U.S. versus Craighead.
Well, but let me interrupt you again before you go on, because I think that in analyzing it, as you correctly point out, with using objective factors, isn't it the fact that it's a police vehicle important?
Absolutely, Your Honor, and we have to look at the police vehicle within the context of the circumstances. And the circumstances in this case was that the defendant voluntarily approached, voluntarily sat in the police car only because she was cold and locked out of her house, that the officer explained the reason why the door was being closed when the officer stated it is really cold out here while reaching to close the door, and the fact that a substantial portion of the conversation between Officer Wright and the defendant constituted small talk about the defendant's swim team. A reasonable person in this situation would absolutely feel free to leave, Your Honor.
Well, if at the beginning, as your learned opponent pointed out, if at the beginning of the conversation is not about the swim team, but the beginning of the conversation is we're investigating a felony hit and run, doesn't, as an objective factor, wouldn't that make a reasonable person feel that this is an interrogation, and thus make them also feel that they're in custody and not free to leave?
Well, to address the interrogation aspect first, Your Honor, the people do concede that an interrogation did take place. However, the interrogation was not custodial, and therefore no Miranda warnings are required. And a reasonable person would still feel free to leave at any time when Officer Wright started the contact this way, because a reasonable person who is aware that she isn't the one who committed such crimes is absolutely going to feel as if at some point that evening she will have the chance to end the conversation and leave.
But where in the case law is there any suggestion that the reasonable person's consciousness of whether or not they committed the crime is a factor?
Your Honor, it is not the defendant herself, her conscience that matters, but rather what a reasonable person would...
But it's not a reasonable person who did commit the offense or who did not commit the offense. It's just a reasonable person believing whether or not they are free to leave.
Absolutely, Your Honor. And in this case, there is no indication that a reasonable person, when approaching Officer Wright voluntarily, would feel as if they were not at liberty to leave. Officer Wright didn't start the interrogation directly by saying, we're investigating a hit-and-run accident. The officer actually started the contact by saying, how are you? Are you okay? Adrian Vega, and then proceeded to ask. Adrian Vega told the defendant exactly what happened, and then the defendant stated, don't you think it's cold out here? And the officer agreed, and at that point, the officer offered the defendant a seat in the back of the patrol car and started talking to the defendant about the defendant's swim team and how the officer was a fan. Now, a reasonable person placed in this sort of a situation is absolutely going to feel as if they are free to leave.
Well, do you think it matters that if you accept an invitation to sit in an officer's car for a reason that's unrelated to the investigation, for example, because you're cold, does that imply that you're consenting to being asked further questions? Is that your argument?
Not necessarily, Your Honor, but in this given case, the defendant voluntarily got inside of the car and continued asking the officer questions. The defendant never gave any indication that she wanted to terminate the interrogation and leave at any time. And a reasonable person, given the circumstances, would feel at liberty like they could ask that question, and that if they asked, the officer would allow them to end the interrogation and leave at any time.
So the burden is on the suspect to ask, may I leave?
No, Your Honor, the burden is not on the suspect to ask, may I leave? However, given what the people's position on this point is that a reasonable person in the defendant's position, because of all of the circumstances that we need to take into consideration, a reasonable person would absolutely feel as if they would be free to leave.
I'm sorry, go ahead.
In the Supreme Court case of Thompson v. Cohane, the court established an objective test to determine whether or not a person is in custody. Given all of the circumstances surrounding an interrogation, would a reasonable person feel as if they were not at liberty to end the interrogation and leave? In this case, there are several reasons why a reasonable person in the defendant's position would feel free to leave. The first being that the defendant voluntarily approached officers and voluntarily sat in the officer's car. This is exactly the issue addressed in the Supreme Court case of Oregon v. Mathiasen, where the defendant who approached officers voluntarily to be questioned was not in custody. Similarly, Adrian Vega approached officers and immediately began answering the officers' questions. The defendant then complained about being cold, and in response, Officer Wright offered the defendant a seat in the back seat of his patrol car, and the defendant accepted that offer because she lost the keys to her house, was stranded outside, and was freezing in the cold. Second, the defendant was not in custody because there were no objective indicia of arrest. In the Supreme Court case of Berkmer v. McCarty, the court found that a temporary roadside detention is not custodial, even if a person is immediately arrested afterwards. In this case, the defendant's freedom was not significantly restrained like that of a person at a roadside questioning. In the defendant's own driveway, being questioned in the back of a warm patrol car is substantially less custodial.
With another officer outside, as the defendant stated, with a rather intimidating presence standing between her and her home, and taking into account that the defendant was 17 years old at the time, do you consider this from the perspective of a reasonable 17-year-old without her parents present? Would she have felt free to leave?
Your Honor, according to the Supreme Court in the case of Yarbrough v. Alvarado, subjective factors like a defendant's age or criminal history is irrelevant in the analysis of custody.
Well, is it a subjective factor or an objective factor? A reasonable person, we're asking whether a reasonable person would have felt free to leave.
Well, it is a subjective factor, Your Honor, if we take into consideration the person's age. However, if we look at this from a reasonable person's standpoint, then it is a factor that this court needs to take into consideration. And regarding Officer Jackson being an intimidating frame outside of the police car, at the very worst, Officer Jackson's presence on the scene was police pressure. And in the Supreme Court case of Oregon v. Mathiasen, the Supreme Court found that police pressure is not tantamount to custody.
Thank you.
Other than voluntarily approaching officers, there not being any objective indicia of arrest, Adrian Vega also had no knowledge that the police car doors were locked. The case of Green v. Superior Court is directly on point in our analysis of this topic. In Green, the court found that a defendant who was questioned in a locked interrogation room was not in custody because the defendant did not know that the room was locked. Similarly, the defendant in this case had no idea that the police car door was locked, as Your Honor pointed out earlier this evening. it is not common knowledge that a reasonable person without experience would have that a police car door locks automatically. Because the defendant did not know that the police car door was locked, this is a major factor to take into consideration. Finally, the defendant was not subject.
Let me interrupt you there, because what the defendant stated is that she didn't know whether or not it was locked. So she didn't know that she was free to leave. So if you consider that, she didn't know that she was free to leave. Looking at it from that perspective, and considering that it's a police vehicle, doesn't that tip the balance into thinking that she didn't really think she was free to leave?
We have to look at the situation here in the given context. And in this context, the police vehicle and the fact that the door is closed does not constitute an environment in which a reasonable person would not feel free to leave. Your Honor, certain locations have a different context depending on the situation.
Exactly. So let's say that let's take the example, let's say the officers had arrived in an unmarked plain vehicle. That would support your argument much more than the fact that they arrived in a police cruiser, which tends to promote the idea that it's a vehicle that one is not as free to exit from. Wouldn't you agree?
Yes, ordinarily.
What makes this not ordinary?
Well, this is not an ordinary situation in that, in this case, the defendant was using the police car to seek shelter because she lost the keys to her from the cold because she lost the keys to her home and had no other way of getting in. In this case, the police car was much more like a jail in New York after Hurricane Sandy, where individuals who were displaced took shelter in the police station. In this case, the tool that the police car was being used for was one to provide the defendant with warmth and shelter from the outside elements, not to place her into custody.
All right, thank you.
Adrian Vega was not exposed to a police-dominated atmosphere like the one articulated in the case of U.S. versus Craighead. In the Craighead case, over half a dozen armed officials converged onto a suspect. In this case, only 2 officers were present, and only one of them had significant contact with the defendant. The other officer stood 15 feet up the defendant's driveway, inspecting the defendant's vehicle, not even paying attention to what Adrian Vega and Officer Wright were doing within the police car. Adrian Vega voluntarily approached officers and voluntarily sat in the back of the officer's car. There were no objective indicia of arrest. The defendant did not know the police car doors were locked, and the defendant was not exposed to a police-dominated atmosphere. Unless the court has any further questions, the people respectfully request that the court deny the defense's motion and admit the statements Adrian Vega made in the back of the police car.
Thank you very much. All right. Rebuttal.
Thank you, Your Honor.
You may proceed, Mr. Williams.
Thank you, Your Honor. Now, opposing counsel stated that Ms. Vega was not in custody and spent a fair amount of time discussing the reason for this was because Ms. Vega voluntarily approached the officers. However, when we look at the context, we'll see that the officers arrived at Ms. Vega's house very late at night while Ms. Vega was out for a walk. Now, Ms. Vega was not approaching the officers. She was returning to her home. It is unreasonable to expect Ms. Vega to do anything else, to maybe approach a neighbor's house and knock on the door and say, "Excuse me, the police are at my house and I really wouldn't like to talk to them. I come to your house." It's not reasonable. So the fact that Ms. Vega approached her home does not mean she was approaching the officers. And to support his argument, opposing counsel cited the case of Oregon versus Mathiasen. However, in Oregon versus Mathiasen, the officer sent the defendant a note asking him to call the police station to set an appointment at his convenience. And this is extremely different than arriving at the defendant's house very late at night and waiting for her to return. Our counsel also stated that Green versus Superior Court supports the idea that Ms. Vega was not in custody. However, when we look at Green, just like our case, there are 2 separate forms of interrogation. Now, in the first one, Green spoke freely and voluntarily to the officers, and the court correctly determined that this was not yet a violation of Miranda custody.
Well, why isn't Green similar to the facts here, where she was speaking voluntarily, your client was speaking voluntarily to the officers? At what point did it, in your view, at what point did it become involuntary? I mean, she gets into the car because she's cold. The door is closed at the same time that the officer gets into the car, also because of the inclement weather. At what point is it involuntary?
Well, Your Honor, the court stated that Green is similar to our case, and Green is similar to our case. It has many, many parallels. Now, in Green, there was an initial consensual interrogation. However, in Green, when the officers, even though Green agreed to remain in the interview room, were called away for a meeting, and a second officer stepped into the interview room to keep watch over Ms. Vega. Now, this officer never spoke to, no, sorry, Your Honor, the officer stepped into the room to keep watch over Green.
Right, but who's keeping watch over Adrian, Ms. Vega? That's where the similarities end, right?
No, Your Honor, not at all. Now, there are several similarities in Green. Now, just like in Green, where a second officer was staring at Green, Officer Jackson was positioned between Ms. Vega and the front door of her home, keeping watch on Ms. Vega. Now, the similarities continue. Now, the officers then eventually returned to the interview room and conducted a second interrogation. Now, the court had determined that this second interrogation was a violation of Green's constitutional rights, stating that Green was left in the interview room with no ready or apparent means of leaving. And this alone constituted Miranda and violated Green's warnings. Now, likewise, we have two moments of interrogation. Now, the first one was conducted when Ms. Vega was detained on the sidewalk in front of her home. And the second one was conducted when Ms. Vega was closed in the police-dominated atmosphere of the police cruiser.
Really, there's three. According to your logic, there would really be three. One, when she's outside the car. Two, when she's in the car before the door is closed. And maybe the third one when the door is closed.
Well, there were two moments of interrogation. Now, the first one was conducted outside while Ms. Vega was detained. And while the doors open, Officer Wright merely spoke about Ms. Vega's swimming career, this not being an interrogation. Then once the officer closed the door to the police cruiser, Officer Wright conducted the second interrogation through the bars of the police caged unit. Now, this was the second interrogation, and it is equivalent to the second interrogation in Green. And the court determined, again, that the second interrogation was a violation of Green's Miranda rights, because Green was left in a police-dominated atmosphere with no ready or apparent means of leaving.
Isn't there a big difference between being in the police station, in a room, within the, I guess you could say the bowels of the police station, versus being in a police car, which you got into voluntarily because it was cold outside? Isn't that a pretty big difference?
Well, there's a difference, but we have to look at the fact that Ms. Vega did not enter the interrogation voluntarily when she entered the police cruiser voluntarily. She was faced with two options outside the police cruiser. Now, she would either continue the interrogation in her front lawn, or she would continue the interrogation inside the back of the police cruiser. So, of course, Ms. Vega opted for the warm seat. However, the option to leave, to terminate the officer's questioning, was never presented to her.
Well, does the case law support the idea that the officers have to tell her that she's free to go, or does it just have to be, does a reasonable person have to believe that he or she is free to go?
Well, the Ninth Circuit case of United States versus Craighead states that whether or not police inform the individual if they're free to leave is certainly a factor to consider.
But it's not required that the officers tell the suspect that he or she is free to go.
It is certainly not dispositive, but it's still a factor that the court should consider.
All right, thank you.
Okay. Now, again, this is akin to the second interrogation in Green, in that Ms. Vega's Miranda rights were violated. Now, counsel also stated the case of Berkmer versus McCarty. However, the court in its Berkmer decision seems to go out of its way to ensure that the reason to ensure that we understood that the reason a traffic DUI stop is not custody is because it is very routine. Our circumstances are not routine. Ms. Vega's constitutional rights were violated, and any statements made must be suppressed.
Thank you. Mr. Tierney.
Yes, Your Honor.
You may proceed with rebuttal argument.
The defense clings to two main arguments, neither of which point to custody in this case. First, that there were three separate interrogations. Yes, the people concede that the very end statements that Officer Wright made were likely to elicit an incriminating response. However, even those statements were not given in a way that would make a reasonable person feel as if they were not free to leave. As to the approach, the initial conversation regarding Officer Wright asking the defendant what happened that night, this was much more similar to the roadside questioning articulated in Berkmer versus McCarty. The defendant was standing on the open roadside with plenty of means of leaving. The defendant had no...
She doesn't have a key to her house, so she can't get into her house. She's 17 years old. It's cold outside. There are two officers present. Where is she going to go?
Your Honor, from a reasonable person's perspective, that person could have continued on their walk or have gone to the guest house in which Tony DeLuca was already inside. There were other options to leave. And given all of these circumstances, the defendant still chose to have the conversation with officers and still chose to get inside the officer's patrol car. Second, the defense exaggerates that during that third interrogation, the defendant was informed she was a main suspect. In the case of Stansberry versus California, the court held that whether or not a suspect is informed they are a suspect is not dispositive of custody. The court further stated that the weight and pertinence of an officer's communication regarding the degree of an officer's suspicions depends upon the facts and circumstances of the given case. And in this case, Officer Wright was neither confrontational nor accusatory. In fact, according to the defendant herself, the most accusatory thing Officer Wright stated was that a bicyclist was hit. Not, you're my main suspect. Not, you're under arrest for committing a felony hit and run. Not even, you were the one driving that car, weren't you? But that a bicyclist was hit. Adrian Vega was not exposed to a custodial interrogation without Miranda rights. For these reasons, the people respectfully request that the court deny the defense's motion and admit the statements Adrian Vega made inside of Officer Wright's patrol car.
Thank you. Extremely fine arguments by both counsel, and I'm especially impressed by your control and your knowledge of the pertinent cases. When I was on the Superior Court for a long time, I heard the law and motion calendar, in the course of which, over a few years, I heard about 10,000 motions argued. So I've heard a lot of motion argument, and I've heard motions since that time, in the 22 years I've been on the bench, and I'd be proud to have either of you argue any motion or oppose any motion in my courtroom. You did a terrific job. I am going to deny the motion, and we can have trial counsel. Oh, do you need a few, I'm sorry, do you need a few seconds to consult with your teacher coaches?
No, Your Honor. No, Your Honor.
All right, thank you. Then let's have trial counsel come forward. All right, I believe that the prosecution has physical evidence.
Yes, Your Honor. The people ask that Exhibit A be pre-marked for identification.
No objection, Your Honor.
All right,
The people have 3 other preliminary matters, Your Honor.
go ahead.
First, the people ask that the reading of the stipulations be waived.
Any objection?
None, Your Honor.
All right, that will be ordered.
Next, the people ask that the court take notice of the latest errata, dated November 1st, 2012. I have a copy if Your Honor would like one.
I believe that those have been provided to me. Thank you, and I'm aware of them.
And finally, the people ask that the witnesses please be excluded at this time.
That motion is granted, and the bailiff will, all the witnesses who are to testify will exit the courtroom at this time. Thank you. All right, so the stipulations do not need to be read, is that right?
Yes, Your Honor.
All right, I will read the charge at this time. You may rise. The people of the state of California charge the defendant, Adrian Vega, with failure to perform a duty following an accident, death, or injury, a felony in violation of Vehicle Code Section 20,001A. All right, thank you. Anything further before the prosecution is called upon to deliver opening statement?
Nothing further, Your Honor.
All right, and you're Mr. Kaufhold, is that correct? Who's delivering the opening for your side?
I am, Your Honor.
Ms. Cole, you may proceed.
On April 19th, 2012, Adrian Vega's panic turned to deception when Adrian slammed into Cameron Douglas with her father's vintage black Bueller, sped away, and instead blamed her friend and teammate, Tony DeLuca. The night of April 19th, 2012 started out as a celebration. The Hidden Valley High School swim team claimed yet another victory, qualifying them for the California State Championship meet. The defendant had an especially exciting night. A swim scout from the University of Los Angeles approached the defendant after the meet to talk about swimming in college. It was the defendant's dream school. Between the big win and the college scout, the defendant was on a rush. She was texting and calling and telling everybody. As the crowd celebrated the victory, the defendant got behind the wheel of her father's vintage black Bueller. But when the defendant got behind the wheel, the texting didn't stop. She drove and texted, bragging to everyone she knew. But what the defendant wasn't doing was paying attention to the road. Meanwhile, an unsuspecting Cameron Douglas was riding her bike home from work. She rode halfway through the intersection of Skyline and Grand, but didn't make it all the way. The defendant, too busy boasting about her recent successes, raced through the stop sign and slammed into Cameron Douglas. Cameron's body flew through the air and landed on the open street. The evidence will show the defendant knew she hit Cameron, but sped away in a panic and with complete disregard for Cameron Douglas's life. There will be 5 key pieces of evidence that will prove the defendant's guilt. First, paint from Cameron Douglas's bicycle was found on the Bueller the defendant was driving that evening. Second, both Cameron Douglas and Tony DeLuca saw the defendant driving the Bueller when it struck Cameron Douglas. Third, an eyewitness, Quinn Liu, saw the driver of the Bueller was wearing a white t-shirt and a red and gold baseball cap, the exact clothes the defendant was wearing that evening. Fourth, both Quinn Liu and another eyewitness, Dallas DeCamp, saw the driver slow down just after hitting Cameron Douglas. Fifth, the defendant admitted to Officer Kelly Wright that she can never forgive herself for hitting Cameron Douglas. The evidence will show the defendant knew she hit Cameron, but sped away in a panic and instead began her plot to blame her friend Tony DeLuca when she was asked what happened and denied hitting anything. But the evidence and the defendant's deception will be clear. The defendant is guilty.
Thank you. And for the defense?
Yes, Your Honor.
All right, you may proceed.
May I have permission to approach the diagram?
You may.
Thank you. Miss Cole just told you that on April 19th, a cyclist was struck by a car, and that the car then drove away without administering aid. Your Honor, that's true. That happened. But what will become apparent is that the driver of that car was not Adrian Vega, but instead the people's own witness, Tony DeLuca. You also heard that there was a swim meet the night of April 19th, that at that meet, Adrian performed well. Her team won, and by the end of the meet, she was extremely excited. Your Honor, that's also true. But what will become clear is that because of Adrian's sense of excitement, because she wanted to tell everyone the good news, she decided to do what she believed to be responsible and safe. She handed the keys to Tony DeLuca. You will hear from 2 witnesses, Taylor Berard and Aubrey Fox, that this act, this handing over of the keys, is consistent with Adrian's character as a responsible young woman. This is also consistent with what Aubrey Fox saw the night in question. She saw Tony DeLuca, not Adrian, standing beside the driver's door of the Bueller mere minutes before the accident. And you will learn about Tony DeLuca. You'll hear that Tony, a foreign exchange student from Italy, came to this country with a dream of swimming for the University of Los Angeles. there was a scout from Tony's dream school at the swim meet that night. But instead of fulfilling Tony's dream, the scout completely ignored Tony. He focused instead on Adrian Vega. By the end of the meet, Tony was angry and upset, and she took out her frustration on the drive home. She drove fast, flew through the stop sign, and ultimately hit Cameron Douglas. The people told you that Cameron Douglas was able to identify the driver by looking up through the windshield of the oncoming car. However, you will hear from Dallas DeCamp, who is standing here, near the intersection, that she saw the accident, and never once did Cameron Douglas look up. In fact, at the moment Cameron Douglas was struck, she was looking down. Your Honor, Vehicle Code Section 20001 requires that the driver of a car render aid to any stricken victim. After all the evidence is presented today, it will be clear that the driver of the car was not Adrian Vega, and that therefore Adrian Vega is not guilty. Thank you.
Thank you. All right, the people may call the first witness.
The people call Quinn Liu.
Thank you.
Before we begin, Your Honor, might I inquire as to the time remaining for closing statement?
Yes?
The people have used 2 minutes and 53 seconds on opening statements and have 6 minutes and 7 seconds remaining. The defense has used 2 minutes and 39 seconds on opening statements and has 6 minutes and 21 seconds remaining for closing.
Thank you.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, I do.
Please be seated. Say your full name and spelling the last of the record.
My name is Quinn Liu. That's L-I-U. Easy name.
Thank you. You may inquire.
Good afternoon, Mr. Liu.
Yes, it is.
Where do you work?
Well, I work at a local bank here in Hidden Valley. I've been a general manager for the past 20 years.
Mr. Liu, directing your attention to what has previously been marked for identification as Exhibit A, do you recognize it?
Yes, I do.
What is it?
It's a diagram of an accident I saw on April 19th, 2012. It's the intersection of Skyline and Grand.
Are you familiar with this intersection?
Yes, of course. I've lived here for the past 20 years.
Is your house marked on Exhibit A?
Yes, it is.
Where?
It's marked in the northeast corner with a Q.
With the court's permission, may the witness please approach Exhibit A?
You may step in.
Mr. Liu, using a blue pen, please mark where you were standing when you witnessed the accident.
I was standing right here on the front steps of my porch.
Describe the accident.
Well, at about 10:30 p.m., I saw Cameron Douglas riding her bicycle on Grand Avenue.
What direction was Cameron traveling?
Cameron was in the northwest corner of the intersection, traveling east.
What happened next?
Well, I saw a black car right around there. It was moving up north on Skyline, speeding.
Then what happened?
Well, I saw what was going to happen. I yelled, "Look out!" I couldn't believe what I was seeing.
What happened next?
I just watched as that black car took out Cameron with its left front bumper.
What happened to Cameron?
Well, she flew through the air, landed in the middle of the road, right in front of me.
Does the C on the diagram accurately represent where Cameron landed?
Yes, it does.
Before I ask you more about Cameron, let's talk about the car. What did it do immediately after hitting Cameron?
Oh, well, it seemed to me that the car slowed down right after hitting Cameron.
Could you see the driver?
Well, I could see what the driver was wearing.
Describe the clothing.
The driver was wearing a white t-shirt and a red and gold baseball cap. I know that for sure.
How could you see the clothing in the dark?
Well, it was illuminated by the light from a cell phone screen.
Objection, Your Honor. Speculation. May I explain?
Yes, you may be heard.
Your Honor, this witness cannot know whether the light actually came from a cell phone screen.
You may respond.
Your Honor, this is a lay witness opinion based on the rational perception of the witness. The witness most likely knows what a cell phone screen looks like, and therefore can testify to what appeared to be a cell phone screen to him.
Well, but he hasn't laid a foundation as to why he holds the opinion that the light came from a cell phone screen. So I'm going to sustain the objection, strike the last part of the witness's answer, and he may attempt to lay the foundation. Thank you.
Where did it look like to you the glow was coming from?
Well, it seemed to me that there was light coming from, shining towards the front of the driver.
What did this light look like?
Well, it appeared to me like it would be a cell phone.
Why?
Well, as I said, the light pointed towards the driver, almost as if the driver would be texting or using their phone while they were driving.
Other than the clothing and the light, did you see anything else?
Yes, I did.
What did you see?
I saw the license plate number. I was able to memorize most of it before the car sped away. It was SLC86.
How could you see the license plate?
Well, I focused on the plate as the car slowed down.
Did you give this plate information to anyone?
Yes, Officer Wright.
After you saw Cameron get hit, what did you do?
Well, I ran over to Cameron to see if I could help.
Did Cameron seem okay?
No, she didn't.
What do you mean?
Well, her whole body was limp. She wasn't responding.
What happened next?
Well, I ran over to my house to call 911, and I wrote down the license plate number that I memorized.
Then what did you do?
I waited by Cameron's side until an ambulance arrived. I told an officer everything that I saw that night.
No further questions, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. May I have permission to approach the diagram?
You may.
May I proceed?
You may.
Good afternoon, Mr. Liu.
Good afternoon.
It was nighttime when you saw the accident, correct?
Oh, yes, it was. Around 10:30.
So it was dark.
Yes, night is dark.
It was cloudy too, wasn't it?
It was that night.
Most of the streetlights were out, weren't they?
It appears so, yes.
In fact, directing your attention back to the diagram, 3 out of the 4 streetlights closest to your house were out, correct?
Yes, they were, although the one closest is still working.
And while that one was working, the rest of the streetlights in the intersection, they weren't, were they?
The ones lower, they were working.
But these ones around the intersection, they
yes, the
weren't,
ones on the
correct?
corners, those weren't working.
You were standing in front of your house, correct?
Yes.
Here on the east side of Grand Avenue?
Actually, it's on the west side.
Yes, you're right. Actually, the north side of Grand Avenue, correct? Here?
Oh, north of Grand, yes.
And the car that you saw was traveling north of Skyline, correct?
Yes, it was.
So as the car passed you, you were standing facing the passenger side of the car, isn't that right?
Well, cars normally do have the driver's side on the
Mr. Luke,
left.
please answer my question.
Oh, I'm sorry, that's a yes.
And so the passenger side was between you and the driver, wasn't it?
Well, I was more focused on the driver.
That wasn't my question. The passenger side was between you and the driver, wasn't it?
Technically, yes.
You tried to see the driver's face, right?
Yes, I did. I could only catch clothes, though.
You couldn't see the face clearly?
Not exactly, no.
And after the car hit the cyclist, you went up to the cyclist and tried to communicate with her, didn't you?
Yes, it was pretty nasty.
She didn't respond, though, did she?
No, she didn't.
Her whole body was limp?
Yes.
Mr. Liu, as all of this was happening, you were panicking, weren't you?
Of course I was. I just saw someone get hit by a car.
Thank you, Mr. Liu. Your Honor, nothing further.
Thank you. Anything further?
Yes, Your Honor. Mr. Liu, was there anything obstructing your view of the driver?
No, there wasn't. I had a clear line of sight.
Do you have any doubts about what you saw in the car?
No, I don't.
What exactly did you see in that car?
I know that the driver was wearing a white t-shirt and a red and gold baseball cap. Cardinal, if you want to be specific.
No further questions, Your Honor.
Thank you. You may step down.
Thank you.
And the people may call their next witness.
The people call Cameron Douglas.
Thank you.
Cameron Douglas?
Before we begin, Your Honor, may I inquire as to the time?
You may.
The people have used 3 minutes and 43 seconds on direct examinations and have 10 minutes and 17 seconds remaining. The defense has used 1 minute and 52 seconds on cross-examination and have 8 minutes and 8 seconds remaining.
Thank you.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? I do. Please be seated. State your full name, spelling the last for the record.
Cameron Douglas, Douglas.
Thank you. You may inquire.
Good afternoon, Miss Douglas.
Good afternoon.
What do you do for a living?
I own a bike shop here in town.
How did you get involved in that business?
I just love the outdoors, and I've always loved biking. Before all this happened, I was a professional athlete.
In what sport?
Triathlon. I used to be one of those crazy endurance athletes.
I want to talk about the night of April 19th, 2012.
Okay.
What were you doing that evening?
Working late, just like every other night. I closed up my shop around 10:30 p.m.
Then what did you do?
It was dark outside, so I put on my headlamp and I hopped on my bike to ride home.
What happened on your way home?
As I was riding through the intersection of Skyline and Grand, I looked up and I saw this black Bueller racing towards me.
What happened next?
The Bueller just blew through a stop sign and hit me.
Did you see the driver's face?
Yes, I did.
Who was it?
Adrian Vega.
Objection, lack of foundation.
Do you wish to expand on that?
Yes, Your Honor. No foundation has been laid as to how this witness knows who Adrian Vega is and therefore knows how to identify her.
Your Honor, I will lay foundation.
All right, thank you. Go ahead.
Miss Douglas, how do you know Cameron Douglas?
Well, I've seen Adrian Vega driving around the neighborhood many times.
And who was the driver that you saw again? I'm sorry.
Adrian Vega.
And is Adrian Vega present in court today?
She's seated over there at the end of the table.
May the record reflect that the witness has identified the defendant?
The record shall so reflect.
Miss Douglas, when did you first see the Bueller speeding towards you?
When I was halfway through the intersection of Skyline and Grand.
What did you do?
There was nothing I could do. It was horrifying. I wanted to get out of the way, but Adrian just slammed into me.
Now, after the defendant hit you, what happened?
I flew through the air, and I landed on the open street.
And then what happened?
As I was lying on the ground, two really nice people helped me until the ambulance arrived.
Were you hurt?
Of course I was.
Starting from your head down, please explain your injuries.
The impact of the Bueller gave me a mild concussion, a broken collarbone, road rash all over my body, and it shattered my right knee.
How has your knee injury affected you?
It took everything I love away from me. Because of my shattered knee, I can never compete in any triathlons again.
No further questions.
Thank you. Cross-examination.
Yes, Your Honor.
Ms. Cunningham?
Yes, it is. May I inquire?
You may.
Good afternoon, Miss Douglas.
Good afternoon.
As you stated on direct, in order for you to see the car coming towards you, you had to look up, didn't you?
Yes.
So, logically, that would mean that you were looking down right before the accident occurred, correct?
Yes, that's correct.
And when the accident occurred, you were listening to your MP3 player, weren't you?
I always listen to it when I ride.
And it's your testimony that you saw the driver of the car that hit you, correct?
Yes, I did.
But you only saw the driver for a split second, isn't that right?
Yeah,
And the accident just happened so quickly, didn't it?
it really did.
And immediately after the accident occurred, you weren't even sure if you spoke or not, isn't that right?
I tried to, but I was just in so much pain.
So you aren't sure if you actually did or not, correct?
No, I'm not sure.
And that Bueller you saw that night, that wasn't the first time you've seen that car, was it?
No, I've seen Adrian driving many times.
In fact, that's how you recognized the car, isn't that right?
Part of the reason.
And you aren't a fan of the Vega family, are you?
Not particularly Mayor Vega.
But you aren't a fan of the way that Adrian Vega is treated around town, are you?
I don't really think anyone should be given special treatment.
And some of that special treatment you feel comes from the police, isn't that right?
Not really, no.
You wrote a witness statement, didn't you?
Yes.
And you were truthful in that statement?
Yes.
And you wrote on page, for court and counsel's benefit, on page 30, line 32, I actually don't think this kid has ever been stopped by the police before, but I think that's because Angelica Vega is Adrian's mother. If you ask me, I think the special treatment should be put to an end. You wrote that, correct?
That's correct.
So you do think she gets special treatment from the police, isn't that right?
I believe they give her some leeway.
And it's your opinion that that special treatment should be put to an end, isn't that right?
No one should get it.
Thank you, Ms. Douglas. Your Honor, nothing further.
Thank you. Redirect.
Yes, Your Honor.
You may inquire.
Ms. Douglas, have your feelings for Mayor Vega affected your testimony here today?
No, Mayor Vega has nothing to do with this.
And does anything change your opinion about the fact that you saw Adrian Vega driving the car that night?
No, I saw Adrian in the driver's seat.
No further questions.
Thank you. You may step down. Thank you. Excused. You may call your next witness.
The people call Tony DeLuca. Before we begin, might I inquire as to the time?
The people have used 6 minutes and 30 seconds on direct examinations and have 7 minutes and 30 seconds remaining. The defense has used 4 minutes and 3 seconds on cross-examination and have 5 minutes and 57 seconds remaining.
Thank you.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? Please be seated. State your full name, spelling the last for the record.
Tony DeLuca, D-E-L-U-C-A.
Thank you. You may inquire.
Good afternoon, Ms. DeLuca.
Good afternoon.
Where were you living in April 2012?
At the Vega household, the Vegas have been incredibly generous to me while I'm in the U.S. I'm a foreign exchange student.
Do you know Adrian Vega?
Yeah, of course.
Is Adrian Vega present in court today?
Yes, she is.
Can you please identify Ms. Vega by location in the court and article of clothing?
She's at the end of the table to my right in a really cute teal blazer.
May the record reflect the witnesses identified the defendant?
The record shall so reflect.
How do you know the defendant?
Well, we spent all of our time together. We lived together, we're friends, and we're teammates on Hidden Valley swim team.
What were you doing the evening of April 19th, 2012?
Like I said, Adrian and I are on the swim team together, and we competed in the state championship qualifying meet that night, which we won.
How did the defendant react to your team's win?
Well, she was excited, but mostly boastful because a scout for the University of LA showed interest in her that night.
Well, what about you? Were you happy for Adrian?
I wanted to be happy for Adrian. I mean, she's my friend, but to be totally honest, of course I was disappointed the scout didn't show interest in me.
What did you do after the meet?
There was a really big crowd celebrating the victory, but I told Adrian we needed to go home so I could get some sleep. I was working at the hospital the next morning.
How did you get home?
Adrian drove us home in the Vegas Bueller, texting the entire time she was driving.
While the defendant was texting and driving, what were you doing?
Well, I was just sitting in the passenger seat with my headphones on and my eyes closed. I was listening to Maroon 5 until Adrian hit something.
What made you think Adrian hit something?
I just felt this big bump.
How did you react?
Well, I asked Adrian, what happened? And she immediately told me, we didn't hit anything.
What did you do?
I argued with her. I was convinced Adrian hit something, but she wouldn't even stop the car to check.
Did the defendant say anything?
She accused me of being crazy and then made up some excuse about there being bumps in the road.
What happened next?
Adrian never stopped, never checked to see what she hit, never checked for damage. She just drove straight home.
What happened once you got home?
The police showed up.
Did you talk to the police?
Yes, I told Officer Wright everything that I knew.
While you were talking to the police, was Adrian there with you?
No, I have no idea where Adrian was.
No further questions, Your Honor.
All right, thank you. Cross-examination.
Yes, Your Honor. May I proceed?
You may inquire.
On the drive home, you thought Adrian was being boastful, correct?
She was bragging a lot.
You became annoyed with her for this, didn't you?
It was kind of rude. She was acting like no one else on the team had any talent.
And what she was bragging about was her meeting with a scout that evening, correct?
For the University of LA.
Your dream school is the University of Los Angeles, isn't it?
Absolutely, #1 school on the West Coast.
And once Miss Vega talked to the scout, you became off-put, didn't you?
Well, it was off-putting that Adrian was bragging a lot.
And you testified on direct that you were disappointed by this, didn't you?
Well, of course, I work really hard to get noticed.
But you tried to be happy for Adrian?
Of course, she's my friend. I live at her house.
It was hard for you to be happy for Adrian, though, wasn't it?
It was frustrating when she was bragging so much.
Yes or no, it was hard for you to be happy for Adrian.
Yes.
Because you've been working hard all year to get that scout's attention, hadn't you?
Not just for that reason, but yeah, of course I wanted to be noticed by the scout.
So yes, you've been working hard all year?
I always work hard, yes.
In fact, you thought that you'd worked just as hard as Adrian had.
I have. I work my butt off.
But the scout didn't speak with you, did he?
No, he didn't. That's okay. I'm gonna keep trying.
Well, you were disappointed by this, weren't you?
Yeah, that's what I said earlier.
You thought that you deserved the university's attention?
Yes, ma'am.
Thank you, Mr. Luca. Your Honor, nothing further.
Thank you. Can you redirect?
Yes, Your Honor.
Go ahead, you may proceed.
Mr. Luca, were you so disappointed that you would lie in court today?
Objection, Your Honor. Oh, I'm sorry, Your Honor.
Go ahead.
No, I'm not gonna lie about anything. I don't lie.
Nothing further, Your Honor.
Thank you. You may sit down.
Thank you.
May I call your next witness?
The people call Officer Kelly Wright. Before we begin, Your Honor, may I inquire as to the time?
Mr. Gonzalez?
The people have used 9 minutes and 5 seconds on direct examination and have 4 minutes and 55 seconds remaining. The defense has used 5 minutes and 34 seconds on cross-examination and have 4 minutes and 26 seconds remaining.
Thank you. Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? I do. Please be seated. State your full name, spelling the last of the record.
Officer Kelly Wright, W-R-I-G-H-T.
Thank you. You may inquire, Ms. Moore.
Good afternoon, Officer Wright.
Good afternoon.
What do you do for a living?
I'm an officer with the Hidden Valley Police Department, and I have been for 12 years now.
Do you have any training or experience investigating traffic collisions?
I do.
Explain your background on that.
I have extensive experience in investigating both traffic collisions and hit-and-run accidents. I've probably investigated hundreds.
Were you on patrol the night of April 19th, 2012?
I was.
Was anyone with you?
My partner, Officer Jackson.
Did you receive a dispatch call around 10:40 that evening?
Yes, ma'am.
Did you respond to the call?
We did.
Where was the call to?
The intersection of Skyline and Grand?
Is that in Hidden Valley, California?
It is.
When you arrived at the intersection of Skyline and Grand, what did you see?
A woman, I later learned to be Cameron Douglas, being loaded into the back of an ambulance.
Was there anyone else around the scene?
Yes, ma'am. There were 2 other people.
Who were they?
Dallas DeCamp and Quinn Liu.
Did you speak with either of these people?
Yes, ma'am.
While speaking with Dallas DeCamp and Quinn Liu, did you obtain any information helpful to your investigation?
I obtained a partial plate number and immediately went to Oliver Vega's home after.
Objection, Your Honor. Hearsay.
Do you wish to expand on that?
Yes. The statement that Officer Wright obtained from Quinn Liu contains hearsay. Well, sorry. What Officer Wright just testified is to hearsay from Quinn Liu.
Your Honor, may I be heard?
Yes, you may.
This is not offered for the truth of the matter asserted, but to show the effect on the listener as shown by officer's subsequent action after receiving this information. Also, Quinn Liu has already testified to this information for the truth of the matter today.
Well, as to the latter point, that's not particularly persuasive, but the objection's overruled to the extent that the testimony is offered not for the truth of the matter, but to show subsequent action. It's admitted.
Your Honor, may I be heard?
No, I've already ruled. Thank you.
On another ground.
Well, you can't make string objections. You have to make all of your,
Okay. Yes, Your
state
Honor.
all the bases at the beginning. Thank you.
May I proceed?
Yes, you may.
After obtaining this information, where did you go?
To Mr. Oliver Vega's home.
Why did you go to the Vega home?
To follow up on evidence I received.
Did you find anything significant to your investigation at the Vega home?
Yes, ma'am.
What did you find?
I found a vintage black Bueller unusually parked in the Vega's driveway.
What do you mean by unusually parked?
It was parked in the driveway, but at an angle with 1 tire on the lawn.
Was there anything about this vehicle that led you to believe it had recently been involved in a collision?
I noticed that there was damage to the Bueller.
What kind of damage?
I located fresh turquoise-colored paint scratches on the Bueller's left front bumper.
Miss Douglas, did you see Cameron Douglas's bicycle at the scene of the accident?
I did.
What color was it?
It was a turquoise bike.
How were you able to determine that the scratches on the Bueller were fresh?
There was a lot of dirt on the bumper of the Bueller, but there was no dirt over the turquoise-colored scratches, which indicated to me a recent paint transfer.
Was there anything else that you noticed about the Bueller?
Despite it being a cold night, the hood of the car was warm to the touch, which I concluded meant the vehicle had in fact recently been driven.
After observing this about the Bueller, what did you do with it?
We had it towed and conducted an inventory search.
Did you find anything during the search?
We did, ma'am.
What did you find?
A University of Los Angeles Swim Scout card.
Where in the car did you find the business card?
Underneath the driver's seat.
Did you find anything else during the search?
We also located a cell phone in the center console.
I want to go back to your investigation of the Vega home. After observing the Bueller, what happened?
Tony DeLuca approached me in the driveway and I interviewed her.
Was Adrian Vega present when you spoke with Tony DeLuca?
2 minutes.
No, ma'am. Only Tony DeLuca was there.
Did you get to speak with Adrian at all that night?
Yes, ma'am.
Is Adrian Vega present in court today?
She is. She's seated to your left wearing the blue sweater.
May the record reflect that the witness has identified the defendant?
The record shall reflect the identification of the defendant.
When did you finally get to speak with the defendant?
After I interviewed Tony.
Did you ultimately make an arrest for the hit and run involving Cameron Douglas?
I arrested Miss Adrian Vega after I interviewed her.
Did the defendant say anything significant during your interview?
Yes. When I expressed to Miss Vega that we thought she may have been the one to hit the bicyclist, Miss Vega said, "It was a bicyclist? I am so sorry."
Did the defendant say anything else?
She said she could never forgive herself.
What was the defendant wearing when you interviewed her?
A white t-shirt,
And what was Tony DeLuca wearing when you interviewed her?
a light blue hidden belly shirt.
Was either of
One
them
minute.
wearing a red and gold cap that night?
Yes, ma'am.
Who was wearing the hat?
Miss Adrian Vega.
Thank you. No further questions.
Cross, Your Honor.
Cross-examination.
Thank you. Good afternoon, Officer Wright.
Good afternoon.
How are you?
I'm great. How are you?
You arrived at the scene of this accident at about 10:40 p.m., correct?
Yes, sir.
And when you got there, you wanted to interview all the witnesses as soon as possible, right?
Yes.
Cameron Douglas was still on scene when you got there, wasn't she?
Yes, being loaded into an ambulance.
And you knew that she was the victim, correct?
I did.
As the victim, she was probably a pretty important witness, wouldn't you say?
Never mind. Sorry.
Yes, sir.
But you didn't interview Miss Douglas at that time, did you?
No, she was currently being loaded into an ambulance to be taken to the hospital.
But she was still on scene, right?
Yes.
You didn't interview her until the next day in the hospital, right?
That is correct, sir.
You did speak to Miss Vega that night, correct?
Yes, sir.
And she cooperated fully with your investigation, right?
She did.
And before she told you anything about what had happened that night, all you mentioned was that you were investigating an accident, correct?
Correct, sir.
And she told you that Tony DeLuca had driven the two of them home and may have hit something, right?
That is what she stated.
She also told you that Tony DeLuca took her hat and phone and had them at the moment of the crash, right?
Yes, that she took the hat, yes.
But you didn't follow up with Tony DeLuca, did you?
No, sir.
At this point, you had two conflicting witness statements from Miss Vega and Miss DeLuca, right?
I did, sir.
And both of them had actually accused each other of driving the Bueller when it struck Cameron Douglas, right?
That is true.
But you arrested Miss Vega without following up with Tony DeLuca, didn't you?
With probable cause, yes.
That wasn't my question. And you hadn't even spoken to the victim at this point, had you?
No, sir.
Thank you, Officer Wright. Nothing further, Your Honor.
Thank you. Redirect.
Yes, Your Honor.
Go ahead.
Okay. Officer Wright, the night of the accident, who was wearing the red and gold baseball cap?
Miss Adrian Vega.
Who was wearing the white t-shirt?
Adrian Vega?
And besides the defendant, did you see anyone else wearing a red and gold baseball cap?
No, ma'am.
Did the defendants ever say anything about Tony DeLuca wearing the hat that night?
No, ma'am.
Objection, Your Honor. This is creation of material fact.
Do you wish to respond?
Your Honor, as there is nothing in Officer Wright's witness statement about Adrian Vega ever saying anything about Tony DeLuca wearing a hat, it is a reasonable inference that Adrian never told Officer Wright that Tony was wearing the hat that night.
Your Honor, may I respond?
Certainly.
If I may direct your attention to page 25, lines 32 through 33. Adrian told me that Tony's apparently upset and grabbed Adrian's hat and phone during the drive home. This is completely opposite of what Officer Wright just testified.
Your Honor, may I be heard?
Did you have anything else?
No, Your Honor.
This statement that the defense has just read says that Tony grabbed the hat. It does not necessarily say that Tony ever put the hat on, which would make it reasonable to assume that Adrian never said that Tony actually put the hat on.
The objection's overruled.
May I proceed?
I believe she answered the last question, so you may ask your next question.
After telling the defendant
30
that you thought the
seconds.
defendant was the one driving the car that hit Cameron Douglas, did the defendant deny any wrongdoing?
No, ma'am.
Did she say, it wasn't me driving?
No, ma'am.
Did she say, Tony was driving the car?
No, ma'am, she did not.
How did the defendant respond?
When I expressed these things to her, Miss Vega said, "It was a bicyclist. I am so sorry. I could never forgive myself."
You spoke with Aubrey Fox after arresting the defendant, correct?
I did.
And Cameron Douglas?
Yes, ma'am.
What did you do with that information?
Time.
No further questions.
Thank you. Thank you. You may step down. Do you have any further witnesses?
No further witnesses, Your Honor. At this time, the people rest subject to the admission of Exhibit A into evidence.
Are you moving it into evidence at this time?
Yes, Your Honor.
Any objection to this?
None, Your Honor.
It is ordered admitted. Thank you. All right. The defense may call its first witness.
Yes, Your Honor. Sorry, the lamp's in the way. The defense calls Adrian Vega.
Adrian Vega, please approach the witness stand. Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? I do. Please be seated. Say your full name, spelling the last for the record.
Adrian Vega, V-E-G-A.
May I proceed?
You may inquire.
Good afternoon, Ms. Vega.
Good afternoon.
How old are you?
I'm 18.
And in April of 2012, did you attend school?
Yes, I was a senior over at Hidden Valley High.
At that point, did you have any plans for after high school?
Definitely. It's my dream to get a swim scholarship to the University of Los Angeles, and then hopefully compete in the 2016 Olympics.
Specifically, do you remember the night of April 19th, 2012?
Of course. It had started out as one of the best nights of my life.
What do you mean by that?
That night, our swim team won the state championship qualifying meet, and after, a scout from the University of Los Angeles approached me and gave me your business card and a hat from the school.
What did you do after you spoke to the scout?
I texted my parents telling them the great news, and then I met up with Tony, and she agreed to drive the two of us home.
Who is Tony?
Tony DeLuca is a foreign exchange student. We were her host family.
And why did you let her drive the car?
My parents are huge advocates of this organization called FAD, Families Against Distracted Driving. And considering everything that had happened that night, I was just way too excited, and I figured Tony would be the safer bet to get us home.
How would you describe her driving that night?
She was driving really recklessly.
What do you mean by that?
Well, when she was going down Skyline, she was just driving way too fast for how windy of a road it is.
Did she do anything else that you would consider reckless on the drive home?
While she was driving, she took the hat the scout had given me and put it on her own head. And then she grabbed my phone and started pressing random buttons on it.
What happened next?
I heard a crash.
Did Miss DeLuca stop the car?
Not at first.
Did she stop the car later on?
Yes, after about a minute or so, I had finally convinced her to pull over.
And what did you do at that point?
I got out of the car, I made Tony switch in places, and I drove the rest of the way home.
Did you do anything once you got home?
I checked out the Bueller, and I noticed that there were some scratches on the front left bumper.
How did you react?
I started freaking out. I thought my parents were going to be furious with me.
Did you tell your parents?
No, they were in town at the time, and that made the whole thing even worse. They trusted me with that car, and to not let anyone else drive it. And I did. I messed up.
Objection, Your Honor, non-responsive.
Overruled.
So, since you didn't tell your parents, what did you do?
I went for a walk to try and collect my thoughts and figure out what I should do next.
Did anything happen once you got back from your walk?
When I got home, I noticed that there were police stationed outside.
Did you speak to those police?
Yes, I did.
What did you tell them?
I told them everything that had happened that night. About Tony driving and taking my hat, about the crash.
Did they tell you anything?
They told me that they believed that my car had been involved in a bicyclist accident that night.
How did you react to that, Miss Vega?
I said, it was a bicyclist. I'm so sorry. I can never forgive myself.
And why did you say that?
I was horrified that my car had been involved in such a terrible accident. And I felt awful for asking Tony to drive that night.
Miss Vega, were you driving the Bueller when it left Hidden Valley High School that night?
No.
Were you driving the Bueller when it struck Cameron Douglas?
No.
Were you driving the Bueller when it left Cameron Douglas in the road?
No, Tony was the one driving.
Thank you, Miss Vega. Nothing further at this time.
Thank you. Cross-examination.
Yes, Your Honor. May I proceed?
You may inquire.
Ms. Vega, on April 19th, you spoke to a swim scout from the University of Los Angeles.
Yes, they approached me after the meet.
She gave you a business card.
Yes, and a hat from school.
That's right, a hat with the school's logo on it, red and gold.
Yes.
You were ecstatic, weren't you?
Of course.
The car you and Tony left the meet in was your father's vintage black Bueller.
Yes, that's the car that I drive.
It's worth a lot of money.
I would think so.
While driving home, you were texting?
No, while Tony was driving.
Right, on your way home, you were texting?
Yes.
And you heard a loud crash in front of the car.
I did.
So surely you called the police.
No, I didn't know what had happened, so.
Well, you immediately had the car stopped?
I tried, but Tony wouldn't pull over.
But the car did stop.
Eventually, she pulled over.
And you switched places because that was the responsible thing?
Yes.
And surely at that point then you called the police while it was stopped.
No, I drove home.
You didn't check for damage first?
Not at that point. I just wanted to get home.
So you drove the rest of the way home, yes?
Yes.
Once you arrived home, you hastily parked in your driveway?
Yes, I did. It was a little crooked, not my best job.
With one tire on the lawn?
Yes.
And then at this point, you called the police, right?
No, I didn't. That's when I checked out the Bueller and I saw the scratches.
That's right, you saw the damage on the car?
Yes.
And at that point, you were panicking?
Yeah, I didn't know what my parents were going to think.
And after you saw the damage, then you called the police, right?
No. At that time, my thoughts were such a mess. I didn't know what to do.
So you took a walk to collect your thoughts?
Exactly.
And then once you had collected your thoughts, then you talked to the police?
That's when I came home and I saw the police there.
Is that a yes?
Yes, that's when I talked to them, when they were there at my house.
When you had arrived home, the two policemen had been waiting for you?
I'm not sure how long they had been there, but they were there and I did talk to them.
This made you feel uncomfortable?
Not originally.
But you did become uncomfortable in the police presence?
Later throughout that night, I did start to feel uncomfortable.
You wondered if they were going to let you go home, didn't you?
Yes, I had no idea I was sitting in the back of a police car.
Officer Wright told you a bicyclist had been hit?
Yes.
And when he said that, you said, "I'm so sorry," didn't you?
Exactly. I feel terrible.
You said you could never forgive yourself.
I can't. I shouldn't have asked Tony to drive.
Objection, Your Honor, non-responsive.
Overruled.
Your headlights were working that night, weren't they?
Yes, they were.
It's only a 5-mile drive between your house and the school?
Yeah, approximately.
No further questions, Your Honor.
Redirect, Your Honor.
Redirect examination, Mr. Whittle. You may inquire. Thank you.
Ms. Vega, who was wearing the hat at the moment of the crash?
Tony was.
And why did you let Tony drive in the first place?
Because I was just way too excited to drive, and I didn't want to be distracted while behind the wheel.
Ms. Vega, why did you not call the police when you went home, when you got home and saw the scratches?
I didn't know what to do at that time. I was freaking out, and by the time I had got back and collected my thoughts, the police were already there.
Why did you tell the police that you were sorry?
Because I shouldn't have asked Tony to drive that night. If I had been the one driving, this wouldn't have happened.
Thank you, Ms. Vega. Your Honor, nothing further. May this witness resume her seat.
Yes, sit down.
Thank you.
And the defense may call its next witness.
The defense calls Taylor Berard.
Thank you.
Please stand here and raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please be seated. Say your full name, spelling the last for the record.
Taylor Berard, B-E-R-A-R-D.
May I proceed?
Thank you, May Park.
Good afternoon, Mr. Berard.
Good afternoon.
What do you do for a living?
Along with getting my master's degree in public policy, I'm also a private swim coach on the side.
What qualifies you to be a swim coach?
Well, I'm sure everyone recognizes me. 2000, Sydney Olympics. I won a bronze medal in the 200 butterfly.
Do you know Adrian Vega?
Yes, I do.
How do you know Adrian?
Adrian's my star athlete. I'm actually trying to get her ready for the 2016 Olympics.
How long have you been working with her?
I've been coaching Adrian for a little over 5 years now.
So do you think you know her well enough to have formed an opinion about how responsible she is?
I think so, yes.
What is your opinion?
Not only do I think Adrian's really responsible, but she's also pretty mature.
What do you base that on?
One time I was driving Adrian to a swim meet, and I pulled out my phone to tweet my fans, and Adrian instantly seemed like she got upset and told me to put my phone away because she takes distracted driving seriously.
Objection, improper character evidence.
We should be heard?
Yes, Your Honor. This is not a character trait of Adrian Vega and therefore cannot be admitted as character evidence of Adrian Vega. It is a specific act offered to show conformity therewith.
Your Honor, may I be heard?
Go ahead.
This is not being offered to prove conduct on a specific occasion. Instead, it's being offered as the basis for this witness's opinion, which the court should hear in order to properly weigh Mr. Berard's opinion of Adrian Vega.
You mean his opinion that she's mature and responsible?
Yes, Your Honor.
Why is that relevant?
That's relevant because the driver of the Bueller that night was irresponsible when they left Cameron Douglas in the middle of the road.
Why is that admissible? Because a defendant may introduce evidence of a defendant's, of his or her reputation for honesty.
Your Honor.
The credibility of the defendant is always an issue for any witness.
Your Honor, may I be
This
heard?
doesn't go to that. Yes, go ahead.
Responsibility is a relevant character trait because, as I said, the driver of the Bueller that night was irresponsible when they left Cameron Douglas in the road. A responsible person would have provided aid. Therefore, this counteracts the prosecution's assertion that Adrian Vega would have left Cameron Douglas in the middle of the road.
The objection sustained.
Do you know Cameron Douglas?
Yes, I do.
How do you know Cameron?
Not only do I shop at Cameron's bike shop constantly, but I'm also a member of the same bike club as Cameron.
What's Bike Club?
First rule of bike club, we do not talk about bike club. Actually, it's just a group of guys who get together and ride bikes.
Have you and Cameron ever talked at one of these meetings?
Yes, we have.
Has she ever talked to you about Mayor Vega?
Yes, Cameron always has something negative to say about the mayor.
Has she said anything specifically about Mayor Vega?
Yes, actually at our most recent meeting, Cameron said that drastic measures need to be taken in order for Mayor Vega to take our biking ride seriously.
Thank you, Mr. Berard. Your Honor, nothing further.
Cross-examination.
Yes, Your Honor. May I proceed? Mr. Berard, you are Adrian's private swim coach, correct?
That is correct.
You've coached Adrian privately for 5 years now?
A little over 5 years, yes.
You're paid by Adrian's parents, right?
Objection. Question calls for the creation of a material fact. May I be heard?
Okay.
Nowhere in this witness's statement does it describe if Miss Adrian Vega's parents pay him or is employed. It merely just says that he is Adrian's private swim coach. It does not detail any type of payment transfer or anything.
Well, but private implies that the payment's being made, doesn't it?
Not necessarily, Your Honor, and any reasonable inferences that are drawn from the witness's statement must be neutral to both sides.
You should be heard.
Your Honor, I believe it is a reasonable inference that...
Maybe a reasonable inference I tend to agree with that, but it's not neutral.
Yes, Your Honor, but as Taylor Berard is a private swim coach, it does imply that he is paid by someone, and that someone would be Adrian's parents.
But the reason that you're trying to introduce is to show that he'd be biased, and therefore it's not neutral. The objection sustained.
Yes, Your Honor. May I proceed? You had a pretty successful swimming career yourself, didn't you?
That is correct. I went to the 2000 Sydney Olympics.
And you even won a bronze medal.
Yes, I did. I'm very proud of that bronze medal.
Now, on the night of April 19th, 2012, you weren't at the intersection of Skyline and Grand, were you?
No, I was not.
You didn't witness the accident?
No, I did not.
Are you aware that the defendant admitted to disobeying her parents by letting someone else drive the Bueller?
I'm not aware of that.
If you were aware of that, would it change your opinion of the defendant being a responsible kid?
Well, I guess it depends on the circumstances.
Is that a yes or a no?
It depends.
You did bail the defendant called you to bail her out of jail, though, correct?
That is correct.
And the Cameron Douglas rants to you about Mayor Vega, not about Adrian. Isn't that right?
Yes, Cameron's always talking negatively about the mayor.
And Cameron's idea of drastic measures was to stage a protest on Skyline and Grand. Isn't that right?
I'm not sure. All I know is that he said that drastic measures need to be taken in order for Mayor Vega to take our biking rights seriously.
Mr. Bard, isn't it true that Cameron Douglas told you that Cameron Douglas would like to stage a protest on Grand Avenue?
Yes, he does want to stage a protest.
No further questions.
Yes, Your Honor. Mr. Berard, does being Adrian's private swim coach affect your honesty here today?
Not at all.
And when Cameron Douglas stated that drastic measures need to be taken, when did he say that? When did she say that?
She actually said it at our most recent bike club meeting.
Thank you, Mr. Berard. Your Honor, nothing further. May this witness please be excused.
Thank you.
You may call your next witness.
The defense calls Aubrey Fox.
Stand here and raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? I do. Please be seated. State your full name, spelling the last for the record.
Aubrey Fox, F-O-X.
Thank you, Your Honor. Good afternoon, Ms. Fox.
Good afternoon.
Do you go to school?
I'm a freshman at San Diego University.
Where are you from?
Originally, I'm from Hidden Valley.
Did you play any sports when you were in Hidden Valley?
Yes, I was on my high school swim team, and I also bike.
From biking, do you know Cameron Douglas?
Yes, I do.
How do you know Cameron?
She's the bike shop owner in town.
Has she ever talked to you before?
Yes.
Has she ever talked to you about bikers' rights?
She has. She's always complaining about how little the mayor does for bikers' rights in town.
Has she said anything else about Mayor Vega?
One time, Cameron said to me, I would do absolutely anything to get the mayor out of office.
Now, going back to swimming, do you recognize anyone in court today from your swim team?
Yes, I do.
Who?
Tony DeLuca and, of course, Adrian Vega.
Can you please point out where Tony's sitting and something that she's wearing?
She's sitting to my right in a beige sweater.
Thank you, Your Honor. Directing your attention to the night of April 19th, 2012, were you at a swim meet that night?
I was, the state qualifying meet.
And what did you do after the meet?
I was looking for Adrian.
Why was that?
I was having a party at my house. No party's complete without her.
Were you ever able to find her?
I was.
Where?
She was in the parking lot with Tony.
Where exactly in the parking lot were they?
They were right next to Adrian's cool vintage car.
How far away were you from where they were standing?
I'd say about 50 feet.
And in relation to the car, where was Tony standing?
She was right next to the driver's door.
Why do you remember that?
Adrian's told me that no one's allowed to drive that car except her, so I thought it was really strange.
What was Tony wearing?
She was wearing a light blue t-shirt.
And what was her demeanor?
She did not seem happy.
Why do you say that?
Well, she'd been scowling for most of the night.
Have you ever seen Tony drive before?
Yes, I have.
Have you ever been in the car with her while she's been driving?
Unfortunately.
So based on being in the car with her and seeing her drive, have you noticed any habits that Tony has when she drives?
Tony has a habit of running stop signs.
And do you have an overall opinion as to Tony's driving?
She's such a terrible driver.
Going back to Adrian, how long have you known her?
We've known each other since we were really little, and we've been swimming together forever.
Does Adrian have a reputation for honesty on the swim team the two of you are on?
She definitely does.
What is that reputation?
She's known for being really honest.
Thank you, Ms. Fox. Your Honor, nothing further.
Thank you. Cross-examination.
Yes, Your Honor.
You may proceed.
Ms. Fox, on the night of April 19th, 2012, after the swim meet, Tony was wearing a light blue t-shirt, correct?
Yes, it was light blue.
You saw Tony and the defendant standing next to Adrian's car?
Yes.
And the door that Tony was standing next to was closed, wasn't it?
Yes, it was.
You never actually saw who drove from the parking lot, did you?
No, I didn't.
In fact, from the time you noticed Tony and the defendant standing next to the car until you noticed they were gone, a few minutes had passed, hadn't they?
Yes.
You were distracted in those few minutes?
Yes, I was.
So you never actually saw Tony get in the car?
No, I didn't see anyone get into the car.
So not Adrian either then?
No.
So you never actually saw who was ever driving the Bueller that night?
No, I didn't.
The defendant has told you that if the defendant were to let anyone else drive the car, the defendant's father would flip out, correct?
Yes, that's what she's told me.
You've known the defendant since you were 5 years old.
Yes.
And it would surprise you if anyone else were to drive the Bueller.
I suppose so, yes.
Is that a yes?
Yes.
No further questions.
Thank you. Redirect examination.
Briefly, Your Honor. Ms. Fox, even though you were distracted for a few minutes, who was the last person you saw by the Bueller that night?
Tony DeLuca.
Thank you, Ms. Fox. Your Honor, nothing further. May this witness be excused?
Yes, you may. You may step down. You may call your next witness.
The defense calls Dallas DeCamp to the stand.
Before we begin, Your Honor, might I inquire as to the time remaining?
Yes, Mr. Gonzalez.
The people have used 5 minutes and 19 seconds on cross-examinations and have 4 minutes and 41 seconds remaining. The defense has used 9 minutes and 45 seconds on direct examinations and have 4 minutes and 15 seconds remaining.
Thank you.
Please stand here and raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? I do. Please be seated. State your full name, spelling the last for the record.
Dallas DeCamp, D-E-C-A-M-P.
Thank you. Ms. Canova, you may inquire.
Thank you.
Good afternoon, Mr. Camp.
Good afternoon.
Where do you live?
I live in Hidden Valley,
Where exactly in Hidden Valley?
in a ranch house near the intersection of Skyline and Grand.
Do you remember the night of April 19th, 2012?
Yes, I do.
What were you doing that night around 10:30 p.m.?
At around 10:30, I had just gotten back home from seeing a movie.
Did anything significant happen when you got home?
Yes, as soon as I got home, I saw a young girl get hit by a car.
Your Honor, may this witness please approach the diagram?
You may step down from the witness stand. Do so.
Mr. Camp, could you please go to the diagram?
Yes.
Do you recognize what this diagram depicts?
Yes, I do.
What is it a diagram of?
It's a diagram of my neighborhood.
To the best of your knowledge, is it an accurate representation of your neighborhood as it was on April 19th?
Yes, it is.
On the diagram, there are a series of X's along the street. What do those represent?
Those are the streetlights in my neighborhood.
What about the X's with circles around them? What are those?
Those were the streetlights that weren't working that night.
Where were you standing when you saw the accident occur?
I was in the driveway of my house.
Could you please indicate where that is on the diagram?
Yes, my house is labeled with a D on the diagram, and the D is inside the box.
Where was the bicyclist?
The bicyclist was on Grand Avenue, headed towards the northeast corner of the intersection.
Thank you. Could you please resume your seat?
Yes.
What was the bicyclist doing as she entered the intersection?
She was looking down and listening to what I think was an MP3 player.
Objection, Your Honor, speculation.
Go ahead.
It is speculation that the biker was actually listening to an MP3 player, Your Honor. That is something that Ms. DeCamp herself cannot know.
Your Honor, may I respond? This witness testified that she thought Ms. Douglas was listening to an MP3 player. As a lay witness, she can testify to her direct observations.
Well, the objection is sustained. You may attempt to elicit what she observed, but you haven't done so yet.
Motion to strike?
The motion to strike is granted.
Mr. Camp, what did you see the bicyclist doing as she crossed the street?
She was looking down and she had earbuds in her ear.
And what happened as she crossed the street?
That was when it happened. The car just slammed into her.
Where was she looking before the car hit her?
She was looking down.
Did you ever see the bicyclist look up?
No, I never saw her look up.
At the moment that she was struck, where was she looking?
She was looking down.
2 minutes.
What happened after the car hit her?
My neighbor, Quinn Liu, ran up to the bicyclist, and then a few moments later, he ran back to his house.
What did you do when Quinn left?
I was so worried, so I ran up to the bicyclist to see if she was okay.
While you were with the bicyclist, did she ever identify the driver to you?
No, she never said who was driving the car that night.
Did she ever say anything to you?
Not anything that I could understand, no.
Thank you, Mr. Camp. Your Honor, nothing further.
Thank you. Cross-examination.
Yes, Your Honor. May I proceed?
You may.
Mr. Camp, on April 19th, you witnessed a vehicle-bicycle collision.
Yes, I did.
This was on the corner of Grand Avenue and Skyline Drive.
Yes, towards the northeast corner.
The bicyclist involved was wearing a headlamp.
Yes, he was.
This headlamp was functional.
Yes, it was working.
You are aware that the bicyclist is a female?
Yes, I'm sorry, she.
The vehicle involved was a 1960s black Bueller GT, correct?
You're correct, yes.
The headlights on this vehicle were also functional?
Yes, they were working that night.
This car was moving really fast up Skyline Drive, wasn't it?
Yes, it was going above the speed limit.
Is that a yes?
Yes, that's a yes.
Immediately after hitting the bicyclist, the car seemed to slow down a bit, didn't it?
It seemed to slow down, but I never saw its brake lights come on.
Yes or no, it seemed to slow down.
Yes, it seemed to slow down.
But the car never stopped, did it?
No, it just kept going up Skyline Drive.
You never actually saw what was inside the car, did you?
No, I didn't see what was inside of the car, but I did see the car.
Yes or no, you didn't see what was inside the car?
No, I did
Objection,
not see
Your Honor.
what...
Asked and answered.
Overruled.
I did not see what was inside the car.
No further questions, Your Honor.
Thank you. Be direct.
Yes, Your Honor. Mr. Camp, while you couldn't see what was inside the car, what were you able to see?
I was able to see, one, the car, and I was able to see it interact with the bicyclist.
And did the bicyclist ever look up to see the car?
No, the bicyclist was looking down.
Thank you, Mr. Camp. Your Honor, may this witness please be excused?
Thank you. You may step down.
Your Honor, at this time, the defense rests.
Right, and now we will hear closing argument from beginning with the people.
Yes, Your Honor. May I proceed?
You may.
Panic, deception. The defendant panicked after striking Tony DeLuca, Cameron Douglas, and the defendant lied and blamed Tony DeLuca. The defendant needed a scapegoat. The prosecution's charges have 4 elements. First, that the defendant was involved in a collision. Second, that the defendant's collision permanently and seriously injured another person. Third, that the defendant knew that another person was probably injured. And 4, that the defendant willfully failed to stop. It is undisputed that there was a collision. It is undisputed that the driver of the Bueller failed to stop. It is undisputed that this collision caused permanent, serious injury, and it is undisputed that the Bueller involved was the Vegas Black Bueller. There are only 2 questions in this case: whether the defendant was driving, and whether the defendant knew that another person had been probably injured. Your Honor, the evidence today has answered both of those questions with a yes. First, let's start with Quinn Liu, who stood on his front porch with a perfect view of the blow that would cripple Cameron Douglas for life. Mr. Liu will never forget what he saw. He will never forget the car, the license plate, or the driver. Mr. Liu will never forget the red and gold baseball cap, the white t-shirt, or the glow of the cell phone inside the car. Remember, there was only one person that night driving a black Bueller who had a cell phone and was wearing a red and gold baseball cap and a white t-shirt. The defendant. Now, the defense is going to stand up and claim that Quinn Liu couldn't see. But it's not what Quinn Liu did not see that night. It is what Quinn Liu did see. The correct car, the correct cap, the correct color of the t-shirt, the glow of the cell phone screen. All by itself. Quinn Liu's unbiased testimony proves beyond a reasonable doubt that the defendant was the one driving the Bueller that night. But Quinn Liu's testimony is corroborated by both Tony DeLuca and Cameron Douglas, both of which identified Adrian Vega as the driver of the car that night. Now that we've put aside the possibility that the defendant wasn't the one driving, we have to address the element of knowledge. Your Honor, as the defendant was driving up Skyline, the headlights were pointed this way. Quinn Liu was standing under the only working streetlight at the intersection. The headlights were shining at Quinn Liu. The defendant must have seen Quinn before even reaching the intersection. Now, after the defendant struck Cameron, the defendant slowed down right in front of Mr. Liu. As Mr. Liu looked in and saw the red and gold baseball cap and the white t-shirt, the defendant must have seen Quinn Liu as well. And at that point, the defendant knew that someone had witnessed her strike Cameron Douglas. At that point, the defendant knew that she needed a deception. So the defendant blamed Tony, put Tony in the hat, gave Tony the cell phone, and moved Tony to the driver's seat. Ms. Vega's panic gave birth to a poorly thought out cover. Blame Tony. But, Your Honor, the forensic evidence that the Bueller, the 1960s vintage model, that was Adrian's father's prized possession that no one else would be allowed to drive, is overwhelming. The defendant would not have allowed Tony to drive. But the defendant asks this court to believe that on the one and only night that Tony drove the Bueller, that was the one and only night that something went wrong. Is this story reasonable? No! And the evidence only gets worse. The red and gold baseball cap that Miss Vega was given, the white t-shirt that Miss Vega was wearing. The defendant and only the defendant had those items in her possession. There are 4 more pieces of evidence that prove that the defendant knew that she struck Cameron Douglas and that it was the defendant who struck Cameron Douglas. First, after hearing the loud crash, Adrian Vega yelled to Tony DeLuca that they didn't hit anything. Now, why did the defendant say that? Because the defendant knew she had hit something. Second, the defendant pulled into her driveway hastily and parked crookedly because she was panicked after hitting Cameron. Third, the defendant went on a walk to collect her thoughts. An honest person doesn't need time to collect their thoughts because the truth doesn't change with time. And fourth, when Officer Wright told the defendant that a bicyclist was hit, the defendant admitted her guilt when she said it was a bicyclist. I'm so sorry. I could never forgive myself. Your Honor, it was the defendant driving the Bueller that night. It was the defendant who struck Cameron Douglas, permanently and seriously injuring her. It was the defendant who knew what she had done, and it was the defendant who failed to stop at the scene. It is the defendant who is guilty of a violation of Vehicle Code 20,001, hit and run.
Thank you.
Closing, Your Honor.
You may proceed.
Mr. Koppel just told you a story of a young swimmer bent on fulfilling their dream. A dream of competing for the best swim school in the West, the University of Los Angeles, and a dream of competing in the Olympics. The way Mr. Koppel has spun this story, it sounds as if there's only one person that fits that description, Adrian Vega. But we know, and the evidence today has shown that there's another person that fits that description. Tony DeLuca traveled all the way from Treviso, Italy, just to swim for an American school. Ms. DeLuca also wants to attend the University of Los Angeles, and Ms. DeLuca also wants to swim in the Olympics. But there are several differences between Ms. Vega and Ms. DeLuca. Ms. DeLuca was not approached by a scout that night. Ms. DeLuca was angry and jealous, and Ms. DeLuca was driving the Bueller when it struck Cameron Douglas. You heard Ms. Vega testify tonight that her encounter with the scout was one of the most exciting moments of her young life. And so naturally, she texted friends and family to let them know of her accomplishments. For that reason, she asked Tony DeLuca to drive. Yes, she had instructions to let no one else drive the car. But Ms. Vega was doing the safe, mature, and responsible thing because she did not think that she could drive home safely while texting that night. What she didn't know is that Ms. DeLuca was angry and jealous, and perhaps in an even worse state to drive than Ms. Vega herself. The testimony of Aubrey Fox confirms Ms. Vega's version of the events. Ms. Fox saw Tony DeLuca standing on the driver's side of the car just seconds before it left the parking lot and just minutes before the accident. Ms. Fox also saw that Tony DeLuca was scowling and upset, just as Ms. Vega described. Ms. DeLuca herself testified that she thought she deserved the scout's attention just as much as Adrian. Does that give Ms. DeLuca motive to run down Cameron Douglas and leave her in the intersection? Of course not. But it does give Tony DeLuca motive to point the finger at Adrian, to bring her down a few notches and to protect her own chances of attending the University of Los Angeles. And so when she spoke to Officer Wright that night, that is exactly what Miss DeLuca did. Point the finger at Adrian Vega. But when Miss Vega spoke to Officer Wright, she told him the truth. She told him that while driving, Tony DeLuca took her hat and phone and began mocking her. Mr. Kaufhold called Miss Vega's version of the events a deception. But you heard Officer Wright testify tonight that before Miss Vega told her anything, all she mentioned was that she was investigating an accident. So when Miss Vega told Officer Wright that Tony DeLuca had her hat and phone at the moment of the collision, she had no way of knowing that Quinn Liu had described the exact same hat and phone to Officer Wright earlier that night. Why would Miss Vega offer such specific detail to Officer Wright before she had any reason to contrive it? Your Honor, it is because Miss Vega's story is the truth. So what is the prosecution left with? Just the identifications from Quinn Liu and Cameron Douglas. Mr. Liu supposedly got such a good look inside the car, he was able to see the color of the shirt that the driver was wearing. But how is it then that Mr. Liu didn't see a passenger? No one in this courtroom today doubts that there was a passenger in the car. Mr. Liu was standing on the passenger side of the car, yet he didn't see anyone there. His testimony is unreliable. For that reason, we can't know what Mr. Liu saw inside the car that night. And Tony DeLuca was wearing a light blue t-shirt. Under the miserable lighting conditions that night, light blue and white would be virtually indistinguishable. Either Mr. Liu mistook the passenger of the car for the driver, or mistook a light blue shirt for a white one. His testimony is flawed and unreliable. And Cameron Douglas said that she saw Miss Vega on the driver's side of the car. But we know that Miss Douglas' story is not true. Dallas DeCamp, an objective third-party witness who even saw the color of the earbuds that Cameron Douglas was wearing, said that Miss Douglas never once looked up. All Miss Douglas saw that night was a black Bueller driving away. The same black Bueller she'd seen Adrian driving around town. The daughter of the very mayor that she wanted out of office, and the kid that she thought received special treatment. Miss Douglas' story is flawed, biased, and does not prove beyond a reasonable doubt that Miss Vega was driving the car. Proof, beyond a reasonable doubt. That this afternoon is the government's burden. But when you look at Tony DeLuca's motive for deception, when you look at all of the evidence that points towards Miss DeLuca as the driver of the car, when you consider the flawed and biased testimonies that the prosecution offered you tonight, when you really look at all of the evidence, Your Honor, there is no proof beyond a reasonable doubt. Adrian Vega is not guilty.
Rebuttal, Your Honor?
You may proceed.
How do we know that Tony DeLuca was telling the truth? How do we know for certain that the defendant was the driver? When the collision occurred, the defendant heard a loud crash at the front of the car. Tony, however, just felt a bump. Now, why? It was because Tony was listening to music. Tony did have her eyes closed, and Tony was falling asleep. Tony wasn't the one who heard an unmuted, loud crash at the front of the car. It was the defendant, and that's how we know that Tony was truthful, and the defendant was the one driving that night. And yet again today, the defendant was deceitful. Refused, once again, to take responsibility for her actions. But the truth is out. The defendant's time is up, and it has been proved beyond a reasonable doubt that the defendant is guilty.
Thank you.
Rebuttal, Your Honor? Your Honor, Mr. Kaufhold made much of what Ms. Vega and Mr. Lucas said that they felt and heard that night. But if Ms. Vega was really driving, then why didn't she feel the bump? The cyclist was struck on the driver's side of the car, and the driver would have felt the bump before the passenger did. Earlier, Mr. Kaufhold also said that the one and only night Tony DeLuca was driving, it's a coincidence that the one and only night Tony DeLuca was driving was the night that there was a crash. Your Honor, it makes perfect sense that the one and only night that Tony DeLuca was driving was the night there was a crash. Tony DeLuca is a terrible driver with a habit of running stop signs. That is why Cameron Douglas was struck that night. Ms. Vega was not the driver, and Ms. Vega is not guilty. Thank you.
Thank you. All right. Do counsel wish to consult with your coaches regarding any trial irregularities?
None from the defense, Your Honor.
None from the people, Your Honor.
First of all, although both teams have presented their disagreements on the evidence and the law very, very skillfully, I think you would agree on this point. It takes a village to raise a mock trial team. So it's time for us to thank the villages that have raised both of you. Your teachers, so let's give a round of applause for all of your teachers. And they're not here today. They may not still be with us. But I remember as I was getting ready today and watching all of you that there were two teachers who made an enormous difference to me. My 7th grade civics, that was still called civics back then, civics teacher, Mrs. Dunn, and my high school government teacher, we called him Coach Bob. I'm sure that all of you have similar teachers who've inspired you to put in all the hard work that you've done for this. So we thank them. I thank them for the great job they've done. And the attorney coaches who've given up so much time to help both teams. A round of applause to them. Everyone else from the Riverside County Office of Education and the Riverside County Bar Association and the Riverside Superior Court, thanks to all of you. And the parents and family members who are here today and have given up a lot of time, I'm sure, nights and weekends to support you all. Hear, hear. You know, I'm reluctant to make any remarks because I don't want to leave anyone out. I'm just so impressed with everyone. The witnesses, my wonderful clerk, Mr. Gonzalez, fabulous bailiff. You've all done a terrific job, and I hope that you've learned a lot about the third branch of government, as well as the dangers of distracted driving, which is something that all of us need to remember, all of us, all age groups need to remember, and that's not a small and insignificant part of, I hope, what you've taken away from this. As to the witnesses, I don't want to single any one of you out because you're all terrific, but Officer Wright, I love the yes ma'ams and the no ma'ams. You just were terrific. You really could be an officer. You know, it just reminded me of an officer so much. I think, who was the so-called Olympian? Incredibly annoying. If that was your goal, you met it. Yeah, and the whole tweeting your fans. All of you, you just were all really in character, but not over the top. You just, sometimes it's a little too much like a drama school, and it wasn't like that. You all just did a really great, believable job. And I agree, Mr. Liu, very easy name. You set up a really nice tone. One thing that impressed me with all of the attorneys is you showed, in terms of the trial attorneys, you showed very good judgment about when to make objections, and you showed excellent responses. Sometimes when I've judged, I don't give as much leeway as I did this time about allowing you to argue the objections and your responses, but I'm glad I did because you did a really good job thinking on your feet. And both responding to the objection and responding with why you thought the evidence should come in. I just can't say what a good job you did on that. Also, both sides did a great job in keeping the questions short and letting the witness, on direct at least, letting the witness tell the story. You know, it's kind of hard to do that. You want to be the one that's telling the story, and it's hard to, step back and let the witness do that. You did a great job with that. Excellent questions, and that's probably why there really weren't that many objections. On one of the things I thought was excellent, both sides, on your cross-examination, you weren't unduly confrontational, and you're comfortable in your own skin and your own way of doing it. That was excellent. I spoke at the beginning, after the pretrial motion, what a good job I thought the pretrial attorneys did. That was a very hard decision, and I'll say my verdict, very, very difficult verdict here because of the excellence of the presentations by counsel and because of the witnesses. But I am having considered everything and deliberated with myself. Since it's a non-jury trial, I find, you need to stand up. The defendant needs to rise as I deliver my verdict, but I find that you are not guilty on count one. But don't ever text, talk on the phone, or do anything but concentrate when you drive. All right. Congratulations to both sides on a terrific job and for your sportsmanship and your courtesy to each other and to the court. If any of you decide to go to law school, I look forward to seeing you appear in front of me someday in the district court. It would be a real pleasure.
Thank you, Your Honor.
We'll call on Kenneth Tang, our superintendent of schools for the county, to announce the county champion, and then Chris Harmon, the County Bar Association president, will be calling on the second place team. Ken?
Thank you, John. Kind of takes the thunder away when you announce second place and there's only two teams, doesn't it? Yeah, so you're all on pins and needles. Well, it is my great pleasure to announce the winning team in just a minute. First of all, I want to say to the students, what a remarkable group of students that we have representing Riverside County. It's very impressive. I've heard those on the jury panel there, the judge mentioning the caliber of students that we have and how well they would do in the actual courthouse, in an actual setting. So those of you that are considering furthering your interest in this, I would encourage you. Also feel like there are some wonderful things that you learn about teamwork, working together on a mock trial team. And I want to commend the coaches for their work in helping you, and I want to commend the parents for all their support. I've heard stories about students that are trying to do the best they can in their classes and trying to do the best they can in mock trial and everything else that goes on in life. And you know, when mock trial is going on, it's a big thing, and it takes a lot of time and effort. And so I admire you for that effort that you put forward. It will pay dividends later on in life. So with that, first place, champion for Riverside County for the mock trial team for 2013 is Poly High School.
Before I announce the second place winner, I'm very pleased big surprise, to present a check on behalf of the Riverside County Bar Association for $1,000 to Poly High School. Good luck. I know you'll make us proud in state competition. In speaking with all of the scoring attorneys today, we all remarked at how close our scores were, and none of us could predict who was going to win. It was that close, and both teams did such a tremendous job. So with a great amount of encouragement and appreciation for your hard work and a lot of pride, second place goes to King High School.
We also, from the County Office of Education, have a $1,000 check for Poly High School. Poly High School, would you please come forward now and accept your award?